Sophia, Communications Counsel at Law Pro. Today I'm going to be talking to you about claims against real estate lawyers. I'll be sharing claims data and real claims-based stories and tips to avoid this happening to you. Real estate claims by count is the second highest category of total claims on average per year, and also the second leading area of law by cost of claims. So, both by number of claims and cost of claims, real estate comes in very high compared to other areas of law. Approximately 50% of currently practicing lawyers will have at least one claim. This is not specific to real estate. It can be very stressful and demoralizing. Our goal here is to show you common mistakes and ways to improve your practice. Communication and inadequate investigation are a close tie for common errors leading to a claim. Today we're going to go through some example of claim types and real claim-based stories. The stories are going to be shared by our claims counsel. And while the stories are about a fictional character, Mr. Harvey Ross, who's the lawyer, the stories themselves are real. Let's start with communication errors. Here are some common types of communication mistakes: failure to follow instructions, obtain consent or inform the client, poor communication, and the famous he said, she said, they said. Here's a real claim-based story.
My name is Scott Jones. I'm a claims counsel in the new claims department at Law Pro. Harvey Ross was retained by Jane and John Doe to act on the sale of their property. They had entered into an agreement of purchase and sale with the buyers. However, the buyers failed to close, putting the deal at risk. The buyers sent an offer to the clients to keep the $10,000 deposit in exchange for mutual releases. Harvey received instructions to reject the offer and instead made an offer of $20,000 to settle the matter. The purchasers accepted the offer. Subsequently, the clients brought a claim against Harvey, claiming that they had never agreed to the $20,000 settlement, as their losses were in fact $180,000. Harvey recalls discussing settlement with the clients and receiving instructions to try and resolve, as the clients intended to relist the property. However, Harvey's notes and written communications with the clients were minimal, and the information was unclear as to what was conveyed between Harvey and the clients and what the clients understood. The parties ended up settling the claim against Harvey. In this case, Harvey should have taken comprehensive notes on the advice given and instructions received, and should have confirmed those instructions in writing, including that settling for $20,000 precluded the clients from claiming additional damages. Without documenting the instructions with the client, we are left with a he said, they said situation, and essentially what comes down to a credibility contest.
Inadequate investigation is the second leading cause of claims. The root cause of inadequate investigation is almost always not digging deeper. Here's a real claim-based story.
My name is Mitch Goldberg, and I'm with the Claims Department at Law Pro. I'm here today to tell you the story of a lawyer by the name of Harvey Ross. He acted for his clients on the purchase of a multi-residential property with a 5-unit rental. The deal closed and everything seemed to go well. A few years later, the purchasers went to sell the property, but work orders were discovered that predated the purchase. So why weren't these work orders discovered at the time the buyers purchased? It's because Mr. Ross did not conduct any off-title searches. The clients brought a claim against Harvey Ross. My initial reaction was, wouldn't this be covered under title insurance? Normally it would have been, except Mr. Ross placed the wrong policy. He asked for a single-family residential policy when really his clients needed a multi-unit policy. Of course, had he purchased a multi-unit policy for his clients, he would have been asked to conduct off-title searches, and the work orders would have been discovered. Mr. Ross really made a couple of interrelated errors. He didn't understand what his clients were purchasing, and then he asked for the wrong policy to be placed. The claim resulted in Law Pro making an indemnity payment on behalf of Mr. Ross, which triggered his deductible and claims levy history surcharge. It should be noted that had Harvey Ross placed a Title Plus policy of insurance, both the deductible and the claims levy history surcharge would have been waived.
Failure to know the law is the third leading cause of claims. There are two types of law regimes in Ontario, substantive and case law. Here's a real claim-based story.
My name is Ellie Persichilli, and I'm claims counsel with Law Pro. Mr. Harvey Ross was retained with respect to a residential real estate purchase. The client's two siblings were non-residents at the time of the transaction. Accordingly, the purchase was subject to the non-resident speculation tax. After the transaction was completed, the siblings became permanent residents. They proceeded to apply for the non-resident speculation tax rebate. Their application was denied. They claimed that Harvey advised them that they would in fact be eligible for the rebate. As Harvey was retained prior to the rescission date in the agreement of purchase and sale, the siblings claim that they would have rescinded the agreement had they received proper legal advice from Harvey with respect to the eligibility criteria. Harvey did not take any notes, nor did he have any specific recollection regarding his discussions with his clients. He knew, however, that he would not have made any representations regarding their entitlement. Pursuant to the criteria for the rebate, while a foreign national can purchase property with another individual, that other individual must be their spouse. As the siblings purchased the property together, the rebate did not apply. Harvey, in this case, should have familiarized himself with the non-resident speculation tax rebate, advise his clients regarding the rather strict criteria. This way, the clients were in a position to make an informed decision regarding the transaction. Harvey also should have, if he did not feel comfortable, advise his clients clearly that he would not be representing them or providing any opinion with respect to the non-resident speculation tax. He could have done so in his retainer agreement or some other written form. Moreover, Harvey should have taken notes regarding his discussions with his clients.
Fraud, fraud, fraud. How many times can we talk about fraud? Well, not enough. Fraud claims have tripled since 2017, and the cost is significantly high and getting higher. Here's a real claim-based story.
Hello, my name is Nadia Delamonte, and I'm the claims manager and counsel for Title Plus Claims. Mr. Harvey Ross was retained by client Jane Doe in connection with the refinance of Jane's property. The transaction involved three components. 1, paying out a mortgage in favor of a major bank. 2, paying out a second mortgage in favor of a private lender. And 3, accessing equity in the home to fund home renovation costs. Unfortunately, a fraudster hacked into the email account of Harvey Ross's law clerk and learned all about the transaction. The fraudster sent a spoofed email purporting to be from client Jane Doe to the law firm to provide instructions with respect to the payment of funds. The fraudster also hacked into the email account of the private lender's lawyer and sent a fraudulent direction with respect to payment of the funds to pay out the second mortgage. Long story short, the fraudster received the funds. Some of the funds were recoverable, some of them were not. What could Harvey Ross's law firm have done differently to avoid this loss? For starters, it's always prudent to verify the account information early on in the transaction. The more time that passes, the more opportunities fraudsters have to manipulate the parties involved into paying funds to the fraudsters. As I always say, call before you click. Had Harvey Ross contacted the parties involved at previously confirmed telephone numbers to verify the legitimacy of the account details, Harvey would have learned that there was a fraud at play.
It's always a good idea to visit your errors and omissions policy with LawPro. Did you know you can increase your social engineering fraud coverage from $250,000 per claim and in the aggregate to $1 million by taking a few simple steps? If you haven't already watched my video, watch it now. Don't be out of pocket. So how do you avoid these types of claims? This question warrants an entire video all by itself, but let's go through some basics. Number 1, do your homework. Ask questions, dig deeper. Does something not make sense? What does your client want? Do your due diligence. And don't dabble in transactions or matters that you're not comfortable with. There are responsible ways to expand into different areas of law and take on more complex files. Number 2, manage the relationship with your client from beginning to end. Have a retainer letter and a retainer, and manage client expectations. Be firm and be consistent. Don't take on matters on short notice unless you feel absolutely comfortable. Often, the mistakes happen when you're rushing. And communicate, communicate, communicate. Number 3, create a paper trail. Get instructions in writing, get directions signed on major decisions, and ensure that you have a reporting or closing letter, non-engagement letter, and I am not your lawyer letter, depending on the situation. There are so many fantastic resources out there to stay current and knowledgeable and have tools at your disposal. LawPro, the Law Society, and other law associations is a great place to start. So, Practice Pro has these resources available 24/7. We also have Avoid a Claim blog website, which is great for current and timely information, and you can also subscribe. We're on social media sharing timely, substantive, and interesting content. Did you know you can call or email us and we'll get back to you? Thank you for watching and stay connected.